to both parties. You had previously ruled, because I'd also asked at that hearing where the court had decided for the home to be sold, that each party be allowed access to some of those funds, particularly because I will need access to some of the funds in order to move. And you said that you would reserve and consider that at the time when the home sells. I need access to those funds. Ms. Baldwin's accusation that I've documented or falsified financial records just isn't true. And it's also really easy to see if there's a joint account, if money's taken out, which person takes it out, where it comes out of. So there's no risk of money being moved without the parties being aware of it. And because you made that ruling that you would decide or that you would be willing to allocate some of those proceeds, it just makes sense to put them in a joint account. It can accrue interest during that time. Both parties can see where the money is, so that I can just know that if the court does make a ruling that I am allowed access to those funds, that I can get immediate access to those, that I'm not trying to have to work through Ms. Baldwin's office, which whatever delay that may or may not incur, that I have funds available should the court allocate those to each party. So that's my only concern. And I guess just a clarification point, I don't know if it needed to be in the presentation order, that when the realtor comes out, if there are any costs to any sort of, not upgrades, but any sort of costs incurring to getting the home ready to sell, that those be split equally among the parties, that I shouldn't be solely responsible for those, as petitioner is still on the mortgages for the house, and they are the party that wanted the home sold and not myself.
Okay, let me start and then I'll turn to you, Ms. Baldwin. So I guess as to the trust account, there are very, 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 very strict guidelines on attorneys' trust accounts. And frankly, the historical posture of this case, I think the trust account is the appropriate place for the funds. If there is an allocation of funds, which I did reserve and said I would be willing to consider to allocate funds, there should not be a significant delay because it's in a trust account versus a joint account. There was, I believe, a contempt that was found previously for on a respondent for essentially doing the thing that you're claiming you're worried about happening to you. So I am not swayed by that argument. So I think the trust account is appropriate. As to any, and I appreciate Ms. Gibson raising this issue because I don't know if that was brought up. So if there is,